On the Laws of England, Book the First, of the Rights of Persons, Chapter the First, of the Absolute Rights of Individuals. The objects of the laws of England are so very numerous and extensive that, in order to consider them with any tolerable ease and perspicuity, it will be necessary to distribute them methodically, under proper and distinct heads, avoiding as much as possible divisions too large and comprehensive on the one hand, and too trifling and minute on the other, both of which are equally productive of confusion. Now, as municipal law is a rule of civil conduct, commanding what is right and prohibiting what is wrong, or, as Cicero, and after him our Blackstone, has expressed it, sanctio justa, jubens honesta, et prohibens contraria, it follows that the primary and principal objects of the law are rights and wrongs. In the prosecution, therefore, of these commentaries, I shall follow this very simple and obvious division, and shall in the first place consider the rights that are commanded, and secondly the wrongs that are forbidden by the laws of England. Rights are, however, liable to another subdivision, being either first those which concern and are next to the persons of men, and are then called jura personarum, or the rights of persons, or they are, secondly, such as a man may acquire over external objects, or things unconnected with his person, which are styled iura rerum, or the rights of things. Wrongs also are divisible into, first, private wrongs, which, being an infringement merely of particular rights, concern individuals only, and are called civil injuries, and secondly, public wrongs, which, being a breach of general and public rights, affect the whole community, and are called crimes and misdemeanours. The objects of the laws of England falling into this fourfold division, the present commentaries will therefore consist of the four following parts. 1. The rights of persons, with the means whereby such rights may be either acquired or lost. 2. The rights of things, with the means also of acquiring and losing them. 3. Private wrongs, or civil injuries, with the means of redressing them by law. 4. Public wrongs, or crimes and misdemeanours, with the means of prevention and punishment. We are now first to consider the rights of persons, with the means of acquiring and losing them. Now the rights of persons that are commanded to be observed by the municipal law are of two sorts. First, such as are due from every citizen, which are usually called civil duties, and secondly, such as belong to him, which is the more popular acceptation of rights or iure. Both may indeed be comprised in this latter division, for, as all social duties are of a relative nature, at the same time that they are due from one man or set of men, they must also be due to another. But I apprehend it will be more clear and easy to consider many of them as duties required from, rather than as rights belonging to, particular persons. Thus, for instance, allegiance is usually, and therefore most easily, considered as the duty of the people, and protection as the duty of the magistrate, and yet they are, reciprocally, the rights as well as duties of each other. Allegiance is the right of the magistrate, and protection the right of the people. Persons also are divided by the law into either natural persons or artificial. Natural persons are such as the God of nature formed us. Artificial are such as created and devised by human laws for the purposes of society and government, which are called corporations, or bodies politic. The rights of persons considered in their natural capacities are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men merely as individuals or single persons. Relative, which are incident to them as members of society, and standing in various relations to each other. The first, that is, absolute rights, will be the subject of the present chapter. By the absolute rights of individuals we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy whether out of society or in it. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal laws should at all explain or enforce them. For the end and intent of such laws being only to regulate the behavior of mankind as they are members of society and stand in various relations to each other, they have consequently no business or concern with any but social or relative duties. Let a man therefore be ever so abandoned in his principles, or vicious in his practice, provided he keeps his wickedness to himself and does not offend against the rules of public decency, he is out of the reach of human laws. But if he makes his vices public, though they be such as seem principally to affect himself, as drunkenness or the like, they then become, by the bad example they set, of pernicious effects to society, and therefore it is then the business of human laws to correct them. Here the circumstance of publication is what alters the nature of the case. Public sobriety is a relative duty, and therefore enjoined by our laws. Private sobriety is an absolute duty, which, whether it be performed or not, human tribunals can never know, and therefore they can never enforce it by any civil sanction. But with respect to rights, the case is different. Human laws define and enforce as well those rights which belong to a man considered as an individual as those which belong to him considered as related to others. For the principal aim of society is to protect individuals in the enjoyment of those absolute rights which were vested in them by the immutable laws of nature, but which could not be preserved in peace without that mutual assistance and intercourse which is gained by the institution of friendly and social communities. Hence it follows that the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. Such rights as are social and relative result from and are posterior to the formation of states and societies, so that to maintain and regulate these is clearly a subsequent consideration. And therefore the principal view of human laws is, or ought always to be, to explain, protect, and enforce such rights as are absolute, which in themselves are few and simple, and then such rights as are relative, which arising from a variety of connections will be far more numerous and more complicated. These will take up a greater space in any code of laws, and hence may appear to be more attended to, though in reality they are not, than the rights of the former kind. Let us therefore proceed to examine how far all laws ought, and how far the laws of England actually do, take notice of these absolute rights, and provide for their lasting security. The absolute rights of man, considered as a free agent, endowed with discernment to know good from evil, and with power of choosing those measures which appear to him to be most desirable, are usually summed up in one general appellation, and denominated the natural liberty of mankind. This natural liberty consists properly in a power of acting as one thinks fit, without any restraint or control, unless by the law of nature. Being a right inherent in us by birth, and one of the gifts of God to man at his creation, when he endued him with the faculty of free will. But every man, when he enters into society, gives up a part of his natural liberty, as the price of so valuable a purchase, and, in consideration of receiving the advantages of mutual commerce, obliges himself to conform to those laws which the community has thought proper to establish. And this species of legal obedience and conformity is infinitely more desirable than that wild and savage liberty which is sacrificed to obtain it. For no man that considers a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, the consequence of which is that every other man would also have the same power, and then there would be no security to individuals in any of the enjoyments of life. Political, therefore, or civil liberty, which is that of a member of society, is no other than natural liberty so far restrained by human laws, and no farther, as is necessary and expedient for the general advantage of the public. Hence we may collect that a law which restrains a man from doing mischief to his fellow citizens, though it diminishes the natural, increases the civil liberty of mankind. But every wanton and causeless restraint of the will of the subject, whether practised by a monarch, a nobility, or a popular assembly, is a degree of tyranny,